Welcome. In today's video, I am going to go over, does the as-is contract in Florida protect you in the event that the property does not appraise for the purchase price? This is one of those questions that, believe it or not, realtors, attorneys, people disagree all the time because there is some nuances. And today I'm going to explain it to you. I'm going to explain the mistake that many people make, all right, why they think that way, and how you can protect yourself if you're contracting. So whether you're a buyer, you're a realtor, whether you're a seller trying to figure out what your rights are, this video is for you, so stay tuned. If this is your first time on my channel, I'm Jonathan Alfonso. I'm a real estate attorney and broker based out of Miami, Florida, and I talk all things real estate related on this channel. Today's video is great because it's one of those rare intersections where I'm allowed to use my knowledge as an attorney and to really understand the nuances of a contract when I'm out there contracting, and I'm able to teach it to my agents and teach it to anybody that works with us. The contract itself does not have any appraisal to purchase price contingency. In fact, and I'm linking to it here, here's an article from Florida Realtors where they have their legal hotline and they put out releases all the time, advising agents, and, flat out, they specifically state there is no appraisal to the purchase price contingency built into the core Florida Realtors Florida Bar contract. All right. They go on to say many people incorrectly believe the language in the contract financing paragraph acts as an appraisal to the purchase price contingency in all cases. All right. And that's what I really want to talk about in this video today, because a lot of people, when they're financing, they're told by their realtor or they're told by somebody in the transaction, oh, the contract has a built-in appraisal contingency. And let me explain to you how it is that they believe that is true. So what I want to do is, so I can explain this to you and so we can all be on the same page, is I want to operate in this video off of the latest version of the Florida FAR Bar as-is contract, because that is what I am basing my analysis on, although it applies a good portion to previous versions of the contract as well, but just to be absolutely clear. And then moving forward is, I want to assume, right, that we're talking about, let's assume section 2 of that contract, right, which has a purchase price and financing. Let's say it was filled out and the purchase price was $1 million, all right, and somebody had put under section 2C that they were going to finance 80%, which would be $800,000. In order to understand this, what you have to understand is the reason people have this mistaken assumption is, and let's look at paragraph 8 of the contract. Paragraph 8 is what covers the financing. And as you can see there, it says that this contract is contingent upon, and it states various terms, buyer getting a loan in the loan amount, all right? And as we just saw in paragraph 2C, they need to get a loan amount of 80% of the purchase price. So if the purchase price is $1 million and they need to get a loan for $800,000, all right, the rationale is, well, if the property were to appraise, let's say for $900,000, then 80% of that would be lower than what is stated on the contract. The problem with this is, this language does not state that it needs to appraise, and it doesn't take into account what other variables could occur for the buyer to still get a loan approval. Going further, some people like to even read into subparagraph 8B2, which states, buyer's mortgage broker or lender having received an appraisal or alternative valuation of the property satisfactory to lender, if either is required by lender, which is sufficient to meet the terms required for lender to provide financing for buyer. Now, some people like to say, see, it says it in there. All right, the buyer needs to receive an appraisal. All it says is it needs to receive an appraisal. It doesn't state what that appraisal needs to state, what amount. You know what else it doesn't state? Getting into some of these issues, what would constitute an appraisal, right? And we'll get a little more into that. Really quick, before I go any further, if I could just ask you for a favor, algorithms are so important. Getting that like and subscribe on the YouTube algorithm is so important. So if you all could just throw us a like, let YouTube know that you're enjoying this video and enjoying this content so we can continue to have as many discussions and reach as many people as possible, I would really appreciate it. Thank you so much. The important thing that I want you all to see here is, and this comes to a principle of contract drafting that is very essential, which is that you have to read a contract as a whole. And also there's other principles, which is, if Florida Bar and Florida Realtors wanted this contract to protect everyone from an appraisal contingency, and they wanted an appraisal to purchase price contingency, why wouldn't they just write it in? Why is it on a separate form that has to be a rider to the contract? It's something for you to think about and marinate on when you're working. So let's dive even further. The law requires us, all right, that when we are looking at a contract, that we can't look at a single clause in isolation without considering the entire contract. All right. And this is important because when it comes to paragraph 8, which is a financing contingency, here's another requirement of this paragraph, which states that buyer's failure to use good faith and diligent effort to obtain loan approval during the loan approval period shall be considered a default under the terms of the contract. And this is the one clause that I think a lot of people are missing when they want to make this argument about, no, if there's a financing contingency, there's a appraisal contingency built in, because the contract requires you to use good faith and diligent effort. So the way I interpret that is, if you get an appraisal that is less than the purchase price and it looks like you're going to get approved for less, you're still going to get a loan approval, all right? And if you have the funds available, you could do it. Or if not, let's say the appraisal came in and the appraisal could be contested. You could have contested it. Maybe you could have ordered another appraisal. Or you could have switched to another lender to then get another appraisal. Or there was another program available to you out there that you could have qualified that required no appraisal. What if your loan program requires no appraisal, but you got one anyways? All right. So how the appraisal factors into your loan is very important and could be brought up in the court of law. See, because the big issue with all of this, and this is what a lot of people don't understand, is when you go in court, when someone goes to represent you, for example, I have litigated cases. I spent 1 year of my life where I literally tallied 1/3 of the days I was in a courtroom. All right. And I have litigated 30 plus appeals. And I can tell you, you can have the most ironclad 40-page contract. Two parties can end up with varying circumstances and they could completely disagree on what otherwise looks like a very simple sentence. And so if you go before a court of law with these arguments that a lot of people make, they don't understand it's not simple. The reason this tends to happen in practice, all right, is that a lot of times realtors get away with it. All right. And what I mean by that is a lot of times buyers, realtors, whatever it may be, because it appraises for less, they come to the seller and the seller says, oh, okay, and they cancel it. That doesn't mean that their conclusion is right? Two wrongs do not make a right, as we all know. It just means that the seller didn't want to pursue it, which I completely understand. Even as I'm making this video, I'm fully aware of there have been numerous circumstances where it doesn't appraise. I know that my seller can make a claim, but they don't want to deal with that and they just want to let it go. And that's fine and that can happen. But I really think if you're the kind of buyer that has a sizable deposit, all right, and you foresee some issues throughout the process, you're going to want to keep this in mind because you may not be fully protected like you think you are just based on this conclusion that's out there. That conclusion has a lot of nuances that could lead to trouble because, for example, what if the buyer has the ability to pay for the property cash? All right. And they would have needed like a smaller loan and they could have still done it. Or what constitutes an appraisal, right? There was a 2007 case, all right, that came out where the buyer tried to get out of the property because it didn't appraise. And then it turns out that there was never an appraisal done. Wachovia, which was the bank at the time that was doing the loan, had its own internal valuation department. And that valuation department had put a value to the property that was less. The seller, when they got to court, argued, you never even had an appraisal done. All right. So we get into another issue, which is the contract does not define what would constitute an appraisal, right? What is it? Does it need to be done by a state certified appraiser in Florida? Or could the valuation, all right, done by maybe a broker, could that be considered other alternative valuation? We get into those issues as well. Now that you understand some of the pitfalls with this clause, let me tell you the biggest mistake that I see many parties make with this, and which is what gets them in trouble with this, appraisal, financing, contingency kind of issue that they get themselves into, is the following: how they exercise their right to get out of the contract. Because what ends up happening is a lot of times what they will do is, and I think this is where they can get themselves into trouble, is they make one of two huge mistakes. The appraisal comes lower, and without doing anything, they immediately have their lender issue a denial letter over to the other side, all right? And now The seller is like, wait a second, you just did the appraisal, you're going through the financing. We never agreed that there was an appraisal contingency, and they get a denial right away. So there needs to be some communication and discussion about what are the alternatives, etc. Because if you just like blindside the seller, that's where I typically see the negotiations go south, instead of where the parties maybe start to have a conversation. Listen, this property appraised for way too low. There's no way we're ever going to get an approval that's going to make sense. The other big mistake is actually one which was a subject of a 2019 case, which is the buyers keep going forward. They actually let the financing contingency expire, right? They get past their approval period, and then the appraisal comes in lower, and they're like, wait a second, we can't get approved. So even assuming that they would have never qualified for any loan, they've let it expire altogether. And that's actually what happened in the 2019 case of, which I'm going to put up on the screen right now, because in that case, the parties had let it lapse, and at that point, the transaction basically becomes cash, and you have no right to get out. And it doesn't matter what your loan approval says, even if you get it after the fact, because the loan approval is deemed to have been obtained, and whatever loan approval you get after your financing contingency period expires, you can't actually use any conditions in that loan, notwithstanding that an appraisal would not be one of the issues that they would allow anyways. Now, I know what you're going to say, Jonathan, explain this to me. Well, if it doesn't have it built in, no seller's ever going to accept an appraisal contingency. How do I manage this? Listen, number one, you can negotiate and try to get an appraisal contingency in there. Even in today's market where it's very competitive and it's very simple, it's how you have that conversations. So a lot of times when I'm representing buyers and I'm trying to get our appraisal contingency in there, it's just a matter of stating, listen, we're going to go, 10, 20, 30, 40, 50, $100,000 over appraisal so you can have that conversation. And even though the listing agent's going to turn and say, well, we're not accepting any contingency, that's usually where I tell them, listen, I understand that, but you and I both know that the buyer that is waiving that appraisal contingency, if the appraisal comes in way low, all right, they're going to try to issue you a denial and get out from the contract, and you're going to end up, dealing with that fight. Whereas with us, we're being very above board, and we're telling you, listen, we're giving you a very high number over appraisal, and based on the comps that you and I are seeing, this shouldn't happen. So wouldn't you want to go with somebody that's being above board and dealing with the issue as opposed to it? Now, that's how we've been able to kind of maneuver them. And that's something that you could, try to do in your transaction. You just have to know how to explain it. All right. The other thing is, obviously, you can get a flat out appraisal contingency. And if it's a less competitive property, you should be able to manage it. If you're a seller, what you're going to want to do is you're going to want to negotiate language into the contract, putting the buyer on notice that if the property is to appraise for less, they're going to cover that difference, all right? And that the loan amount will be adjusted automatically, and that a lower appraisal will not be grounds for terminating the contract. That way, you're making it very clear at the outset. And the beauty about this is, I know that it seems like it's very aggressive, but at least, listen, better to put that out there at the outset when you have your pick of the litter of the buyers than waiting until, 20 days in, and now the buyer is getting a lower appraisal and they're trying to cancel. At least now you have a clause in the contract already getting rid of that issue and moving forward, so you don't have this battle of, how are we going to define whether the financing contingency gives the buyer an out. If you've had a contract with a financing contingency and the appraisal became an issue, tell me your story below. I'd love to hear your conversations of situations that you guys have run into. How are you approaching it in this market? I'd love to have the discussion below. Thank you all for joining, and I look forward to seeing you guys on my next video.